Good morning, everyone. I am Rahul Nanuhal, co-founder and CEO at JustAct, an ODI platform enabling enterprises, institutions, and individuals to resolve disputes efficiently and affordably using technology. The moment we are in, there is more movement in the arbitration and ADR space in India. Legislative reforms have been initiated, institutions are being established, with the judiciary at the forefront. For example, today, Chief Justice of India, Justice Suryakant, is set to launch Chandigarh International Arbitration Center, where Chandigarh will formally join India's growing network of recognized arbitration centers. These are necessary changes, but it is not sufficient. Recently, Chief Justice of India, Justice Suryakant, has flagged trust deficit as a core reason India is not yet a preferred dispute resolution forum internationally. But things are happening in parallel across legislation, judiciary, institutions, practitioners. But what does it all mean? What is the way forward? How does it come together? That is what this webinar is for whoever you are in the ecosystem. Questions directly to them and get credible perspectives. We have two of the most prominent voices in the space joining here today. Justice Hemant Gupta, former judge of the Supreme Court of India and a fellow of the Chartered Institute of Arbitrators, brings rare judicial insight and intellectual rigor. Mr. Jawad AJ, a trailblazer in the ADR movement in India, registrar at IAMC Hyderabad, senior mediator trainer with the Supreme Court's MCPC, someone who has built the institutional infrastructure of dispute resolution from the ground up for decades now. To start the first session, let me hand over the stage to Chitra Narayan, founding partner of the Foundation for Comprehensive Dispute Resolution in Chennai. Chitra was trained as a mediator in 2003 and has been mediating commercial and non-commercial disputes since 2005. Chitra is a certified mediator with the Tamil Nadu Mediation and Conciliation Center, attached to the Madras High Court. She's also a certified mediator with the ADR Group, UK. We could not have asked for a better person to start this session. Over to you, Chitra.
Thank you very much indeed, Rahul. Good morning, sir. Welcome to the webinar, and good morning to everyone, and welcome to this webinar series by JustAct. JustAct has planned a series of webinars dealing with various facets of appropriate dispute resolution in India and in comparative jurisdictions. This is the inaugural webinar, and we're indeed really happy that it is Justice Hemant Gupta, the retired judge of the Supreme Court of India, who will start the webinar series. I think everyone knows about Justice Hemant Gupta, and Rahul spoke a little bit about his work, but there are certain facets to his work that I want to emphasize. It's not an introduction as much as an emphasis on the kind of person we have to start this webinar series. So Justice Gupta has practiced for 20 years, and from 1980, he joined the bench in 2002, went up to the Supreme Court, and he retired in 2022. He is a fellow of the Chartered Institute of Arbitrators, and he was appointed a chairperson of the New Delhi International Arbitration Center. This is not a position he holds anymore, but this is the kind of credibility he brings, and the weight that his engagement today will bring for us. He has always advocated a move from a litigation-heavy culture to a resolution-oriented approach. He foregrounds this in institutional strength, autonomy, and global credibility. He has contributed significantly in integrating technology in the practice of law. During his time in the Punjab and Haryana High Court, he was part of a committee that oversaw case management systems, digitizing court records, establishing e-filing of cases. So we're very happy, Justice Gupta, that you are here in the inaugural session today.
Thank you, Chitra.
The way we are structuring this, the webinar today is that there will be three sets of discussions. The first is this discussion with Justice Gupta, which will be for an hour. This will be followed by a discussion which will be with Mr. A.J. Jawad, Registrar of IAMC. And this is followed by a panel discussion with both Justice Gupta as well as Mr. A.J. Jawad. So it promises to be a long and interesting discussion today. So how I intend to structure this session, this 1 hour session, is that we will speak, we will have a discussion with Justice Gupta for about 40 minutes. And then we open the floor for audience to ask questions. There is a chat provided where you can put in your questions. Please raise your questions in the chat as you hear this discussions going, and we will take up these questions at the end of about 40 minutes. Right? So Justice Gupta, let me start with asking you, in your 2 decades as a judge, where do you what moments or what events or event do you think has been momentous for arbitration in India?
I think there is a lot of case law which got developed within the last 20 years. Some were good, some were not so good. But the fact remains that we have traveled a long way from 1996 till today. The legislative amendments have code, some different new interpretations have been given to some of the cases. Broadly, I would say that it was not a watershed era, but really a remarkable era, I would say so. Like 20 years is not substantial in the age of a nation, but in the age of arbitration field, it is quite substantial. What we could have done, probably we were late. You know, when the economic liberalization happened in 1990-1991, the Arbitration Act should have been amended, or new act should have been brought at that stage. But we missed that opportunity. The commercial world was not made wiser with the new legislative amendments. We continued with 1940 Act for another 6 years. And after 6 years also, we copied the ancestral model law verbatim. Actually, there was not a comma or full stop change, which is actually, I feel that it was not in the context of India, you know, this ancestral model of law. A small mistake, I would say, like it says that Chief Justice will appoint the arbitrator, Chief Justice of the High Court or Chief Justice of the Supreme Court. But in our country, it is always the institution, not the person specific, not the holder of the office. And it had taken a long time. 2015, the word Chief Justice was substituted with the word High Court or the Supreme Court. The work culture of our country is very different from European countries. But ancestral model of law was mostly by a result of the experience from the European countries, I would say so, European or American countries. But we have a very different style of functioning. Like I will give you example, like section 34, this is award can be set aside if it is against the fundamental policy of Indian law. What is fundamental policy is was not defined or interpreted in the section 34. Then what happened was the Supreme Court has to intervene and to say patent illegality is a fundamental policy. Patent illegality was picked up from 1940 Act. So these are the difficulties which we should have been careful to while enacting law. But those amendments, though the section 34 has been amended in 2015, but the substantial grounds of challenge are still left to be interpreted by the Supreme Court. The ground should be simple, straight, and forward. Not that for one interpretation we have to bank upon another interpretation. It should be state that award which is sufferable, like under the 1940 Act, it was material irregularity. So those grounds would cover actually the most of the field. Ultimately it is the court which interprets the scope of section 34, section 11, and so on and so forth. But some or the other, we have missed that opportunity. Even for that matter, section 11, appointment of an arbitrator. This should have been, if we were to take a break from the old system, the arbitrator should not be appointed, the ad hoc arbitration should not have been resorted to in the first instance. The institutions were there, not many, but there were a couple of institutions who were dealing in the arbitration. Many might have come if we have said that you will go to the institution. But once we are comfortable with a particular line of action, line of thought, it is very difficult to now change statutorily to say there will be no ad hoc arbitration, but institutional arbitration. There are difficulties, like Arbitration Council of India was conceived in 2019, but it has not come into force. The Arbitration Council of India was intended to recognize or rate the arbitrators, and then those arbitrators would have would become a pool with the high courts. But the first step itself has been not taken. Then what will happen to the second and third stage is mistaken. It will take a long time. That's what I would like to say in respect to your first question.
Thank you, Justice Gupta. You have spoken about the good and the bad in the past 2 decades, and I'm happy that that is that this is a reckoning of where we are going with arbitration. So we've had many committees, we've had many amendments in the past few decades to the Arbitration Act. So one of the committees, or the latest committee that we have on the law, is the T.K. Viswanathan committee, which has made suggestions on arbitration law. And one of its strongest suggestions, though it hasn't gone into great detail about it, is the point you make as well, that did we take a cautious decision when we adopted the arbitral model law on international commercial arbitration, completely. And the the T.K. Viswanathan committee says we should have a separate domestic law. So we've adopted the norms for instance, enforcing arbitral awards, which are there in the arbitral model law, even for domestic arbitrations. I mean, and you've spoken a little bit about the difficulties that has caused us. So they say we should have a domestic law, and they say this domestic law that will address India's specific concerns. So could you speak a little bit about what your thoughts are on what such a law could be? What such a domestic law could be that could address India's specific concerns?
No, before 1996 Act, there was separate law for domestic arbitration and separate for the international enforcement of international arbitration awards. The grounds of challenge of the awards are also separate. The procedure is separate. I think it makes good sense to have a separate law rather than confuse the same law, whether is chapter part 1 or part 2 is applicable. It should be clearly, if there is a separate law, it will be easier for the students of law to follow which provision has to go. Sometimes, like whether patent illegality is a ground for challenge of the international award is also one of the was one of the arguments raised. Of course, the court has not accepted that it is only the patent illegality is a ground to challenge a domestic award. But I think is a separate law would be a better option. What happened was ancestral model of law was probably India's commitment to World Trade Organization that will bring law, will modify for the ease of doing business. But as I understand, I'm not very sure, that as the deadline was about to approach, they came out with this act in a hurry without examining the Indian context and Indian litigating nature. Every country has a different. We are very litigious country, so we have to take care of those things while enacting law. But some or the other, we followed that the norms of judicial tolerance or judicial interference in other countries would be followed by India. That it doesn't happen that way. So there is 1996 Act was not the new act. We had the background. 1940 Act was there. So we have to provide continuity of thought, continuity of the thought process. We can't change it. If we have to change it in a clear manner, not in a indirect way. That's what I feel is the difficulty. Vishwanathan Committee has given very good suggestions, and the bill has been introduced in 2024. It's almost 2 years, not 2 years, probably 18 months. But still, it has not been introduced in Parliament. Either of the houses of Parliament is still with the ministry. Probably it would have been better if it comes in a public domain. The bill is in public domain, but in a private, it's not in public domain in the sense when the bill is introduced in Parliament, the people are willing to debate clause by clause that how to go about it. I think we have much is required to be done in that field.
Yes, and I thought I would ask for your views on this very vexed issue of public policy as a ground for challenge of arbitral awards. On the one hand, we are concerned with judicial oversight. We don't want any serious errors to happen in arbitration. And I think the curative jurisprudence, the petition, the order passed by the Supreme Court in the MMRL matter is an example. And on the other hand, we also want expedition. We don't want unnecessary interference in the arbitration process or in the decisions that are given in arbitration. Where do we draw this balance? I think in drawing this balance, the public policy ground has been much vexed. So how would you suggest, or are there any thoughts that you have on where the balance can be drawn between judicial oversight and minimizing interference or in arbitral proceedings?
No, one thing I would be very emphatically say that there can be mistakes, bona fide mistakes, intentional mistakes, or whatever, maybe the other reasons. We can't give absolute immunity to an award of the arbitrator. That will also lead to free hand to the arbitrators, and the world over, in all awards are subject matter of challenge. To what extent the court interferes is something very different, but not to have power to challenge would be a very different issue. Now, once the power is there, to what extent the power is exercised is again, in Indian system, is a judge-made law. Whether it is a public policy or not, whether award interdicts public policy, has to be interpreted by the court. In a given case, my experience as a judge would be, if the court is satisfied that everything is fair and reasonable, the court will hold its hand back. But where the judge is satisfied there is something grossly remiss, the court will find some reason to interfere. It's ultimately satisfaction of the court. Without the satisfaction of the court, you can't get an order. All these words, public policy, fundamental public policy, patent illegality, ultimately, it's a very thin line of difference between public policy and public patent illegality. If the court is satisfied, it will fall within the patent illegality. If court is not satisfied, it will say that no patent illegality. It's very, very subjective, but it's the facts of each case which will determine. As you mentioned about the curative petition, maybe the court is actually that in Delhi Metro's case, DMRC, it is probably the first time the court has exercised the curative petition to set aside an order of the Supreme Court. It has not happened earlier, or I don't know whether it will happen again later. But the fact is, there must be some strong reasons why the court interfered with. Sometimes, in black and white, the reasons won't come, because the line of reasoning has to be on the basis of facts of the case. But the bench must be convinced, I would say so, that there is something remiss which warrants interference. Sometimes it is difficult to articulate, to say that it's a patent illegality, that particular fact is patent illegality. But ultimately, 5 judges have found that it suffers from error apparent. Then we have to give that allowance to the court. Criticizing it by the students of law is one reason. We can say that this particular aspect was not considered or not considered, but the fact remains that 5 judges have found a particular ground to interfere, and it is again in a lighter vein. It is not in favor of, the order was not in favor of a private entity. It was in favor of the government entity. So either we go to the extent of saying that judges were influenced by the government or something, which I don't know. this in execution, there was execution was pending before Delhi High Court. The decree holder filed an application for attachment of the metro trains. So the act was amended, the Delhi Metro Act was amended to say that the rolling stocks cannot be attached because it's a public policy. It's a public convenience. People will suffer if you attach a rolling stock. Then who will suffer? These are the background in which the matter came up before the curative bench. So I think that's enough for this answer.
Thank you, sir. Staying with the proposed amendments that are there in the 2024 bill, we find that there is a proposal that the Section 8 petitions, these are applications. These are applications which are filed in a case which is pending before the court, where the party says that, look, there is an arbitration agreement and therefore please, refer the case back to arbitration, as well as Section 11 applications. These are applications that are filed in the High Court and the Supreme Court for the appointment of an arbitrator, where the parties are not able to agree or implement their arrangement for appointing an arbitrator. This is for the benefit of participants. So the committee says that there must be a time limit within which this is decided. It also says that if there is a Section 16 application, which is an application before the arbitrator challenging the jurisdiction of the arbitrator in the case, that should be decided in 30 days. We have seen, very laudatory undoubtedly, because we do want these to be decided quickly. Delay plagues us and we want to address it. And there are many laws, I think the Family Courts Act, the Specific Relief Amendment Act, all of which set time limits within which certain decisions have to be taken by courts. And we find overwhelmingly that the courts are unable to do this. So what would you think would be the purpose, or in setting these time limits in these laws or in these proposed amendments within which decisions are to be taken by the courts?
When the court or the law mandates the court to decide it, there are n number of judgments to say it is directory, because you can't. You can make certain provisions mandatory. The action has to be taken by the party, but you don't have a control over the court. That only this time limit only is to show that it's require expeditious disposal. Like 226 subclause 3 says that an application for vacation of stay shall be decided within 15 days, but nobody has ever decided it within 15 days. So these are the practical issues. Time limits are meant for the individuals, not for the court. We have more and more time limits are fixed, like in you mentioned about the family law, that 6 months the matter will be decided. But what does it mean? 6 months it is not decided. Does it mean that divorce is deemed to be granted or deemed to be declined? It can't be. Same way, it's only for the reason, like CPC was amended, Order 8 was amended, that you will file your statement of defense within 90 days. The court has said that it is only directory, because that was actually an action to be taken by the party. But still the court said that since no penal consequences follows from the time limit, it becomes a directory. But this omission was in a way met when the Commercial Courts Act was enacted. They made it mandatory that if within 90 days you don't file your statement of defense, your defense will be deemed to be struck off. Therefore, all these provisions, like within 30 days or 90 days or whatever, is only to impress upon the court that please don't sit over the matter, take up expeditiously. According to me, the Arbitration Act, 1996 Act, has multiple civil court intervention. Before the award, before the matter goes to the court, Section 8, then Section 9, then 16, 11, 16, 17, 34, 37. If we have to make the Arbitration Act workable, effectively workable, without the intervention of the court has to be reduced. It is that delay is basically in the courts, because the courts have exercised multiple jurisdictions. They have criminal jurisdiction, they have a writ jurisdiction, they have hundreds of like surface and other things. So we can't take away the jurisdiction of the High Court or the Supreme Court because of L. Chandra Kumar's case. But the fact remains that we have to provide an alternative to the litigants. And one way was that we strengthen our institutions where the matter can be taken up. But some or the other, the courts, the legislature and the courts have not promoted institutional arbitration, I would say so.
Thank you, sir. I wanted to talk about a few judgments. Again, these are important, and given the topic that we have today, future of arbitration in India, I think these judgments have sort of shown a certain path in terms of where we are headed with arbitration in India. The first of the judgments is the PSL Wind Solution System, the 2021 judgment, which followed the Atlas Export judgment. This is a case in which two domestic parties opted for a foreign seat for the arbitration. They decided to conduct their arbitration outside India. And, in the facts of each of these cases, both the parties went ahead with the arbitration and completed the arbitration outside India. And then one of them, chose to question, whether two domestic parties could actually conduct their arbitration outside India or have their seat of arbitration outside India. The Supreme Court in both cases, of course, was influenced by the fact that the arbitration had been completed and that this objection was raised belatedly, possibly, not a genuine question being asked by the party. And the court said in each case that it was open to domestic parties, to two or more domestic parties, to cite or to keep their, the seat of arbitration outside India. Now, given that this means that the curial law is going to be the law of the place or the seat of the arbitration, I have two questions for you. The first is, what do you think of these judgments where domestic parties now can, parties, particularly where there is an Indian and a foreign party, they tend to choose, places outside India, Singapore or ICC, London, to conduct their arbitrations. Now, what can we do? Why is it that, there is this option being exercised of not, citing your arbitration in India? And what is it that we can do to dispel this either perception or this desire to, cite the arbitrations outside?
Yes, actually, it's the most important aspect where Indian parties executing contract in India resolve to get their disputes from a foreign-seated arbitration. The idea seems to be that they will have a quick conclusions of the proceedings. The objections are decided fast. There are no appeals, or appeals are also taken care of very fast. But in India, firstly, because in India, mostly 90% of the arbitrations are ad hoc, the institution has no role, and which is not true in even in Singapore, London, or Paris. It is only the institutions who regulate, who conduct arbitration. So ad hoc arbitration, there is no control of anybody, except the arbitrator, how he conducts it. To earlier, there were many arbitrations which are pending for years. Therefore, the time limit has come that within 12 years, 12 months of conclusion of the pleading, you will decide. And then parties can extend only 6 months. Then you have to go to the court. It's only to impress upon it that the ad hoc arbitration, all these time limits are meant for ad hoc arbitration, not for institutional arbitration. That some mechanism is required to be carved out for ad hoc arbitration to decide it expeditiously. Second, I think I will have a different take about the judgments. Once the parties are in India, they decide, and their contract is regulated by Indian law. Why should they be permitted to agitate the matters before the foreign tribunal only because one finds it convenient? Or maybe it started with Balco, in 2014, Justice Nija's judgment, that parties can decide to have arbitration, seat of the arbitration outside India. But then in that case, the clause of the agreement was very different. The parties will be governed by Indian law, but for arbitration, they will be governed by law of London. And then seat of the arbitration would be, the with all respect to the members of the bar, why can't there could be a simple clause that parties are Indian, governed by Indian law, the seat of arbitration shall be India. In Punjabi, they said it's a jalebi banana. No, it's a regrettable thing. Don't talk straight, talks in a circuitous way. And possibly, because of those judgments, the institutional arbitration in India has not progressed because the people find it easy to go to other countries. It's expensive. London lawyers are expensive, so are the Singapore lawyers. The Indian lawyers are actually competent. We speak the same language as in Singapore or in London. We have a better infrastructure, not better, but equally good infrastructure. Then why should we go to the other countries? We should have love for our country rather than denounce it. Chitra, what I find is some or the other, we find Indians find that India is not good for arbitration. London will be good or Singapore will be good. We don't love our country. We are more enamored with the foreign jurisdictions, maybe for financial reason or maybe for spinal reason. But ultimately, had the matter been before the civil court, it would have been in India only. But why in arbitration you are giving that leeway that you can get your matter decided by a foreign court? When the contract is executed in India, parties are in India. Actually, instead of seat of arbitration in India, seat of contract should be more important. Where the work was executed. That should be the central theme. But now there are judgments after judgments. We can't help it out. The only way is to amend the law, but I don't think so. Vishwanath Committee has given any suggestion regarding this law.
Thank you, sir. The other judgment that I wanted to quickly refer before we open it out to the participants, and there are a lot of questions on the chat that I can see, is the judgment of Cox and Kings, where the Supreme Court has after evaluating a series of cases, has now said that one does not have to be a signatory or a party to the arbitration agreement. If the court finds or the arbitrator finds that there is a person connected with one of the parties to the agreement who has been involved in the setting up, in the implementation and the execution of the underlying contract, and that it would be the person would be a veritable or a necessary party to the arbitration in order to decide the issues that come up. The arbitrator should be empowered to implead that person as a party to the arbitration. We have, in giving this decision, actually moved forward or taken steps that several other jurisdictions have not adopted. England hasn't, the USA hasn't in many cases. So what are your views on how this would enable the arbitration ecosystem in our country?
Chitra, the difficulty is we always want to see an interpretation of law or the statute with the eyes of Europeans or Americans. In India, there is a well-known concept of engaging subcontractors or independent contractors to execute the same part of the contract. Like there is a contract for erection of a power plant. One team will not do it. Say, Larsen and Toubro will not execute all parts of the contract. There will be machinery will be provided by another supplier. There are multiple. It's a teamwork where each team is a separate vertical. In India, that makes sense in the sense that non-signatories can be made because ultimately they are driving their power from the main contractor. One can understand, if there is a altogether different independent contractor, nothing to do with the main contract, then possibly we can say that no, he or it should not be joined. But if the contract is the mega contract and there are multiple subcontractors are engaged by the contractor, it's better to give finality to the dispute to join everyone in the same contract. But there has to be one contract and others are subcontractors. But Cox and Kings doesn't say in so many words. So, as I said earlier, the Indian context has to be kept in view while enacting law. We are good in, say, at the time of execution of the contract, we are good, we'll be all willing to contract. But in case of a dispute, we'll be all willing to contract out, that we were not concerned with it. This contract is not binding. That is that situation has to be kept in view. Maybe it's for that reason I will support that judgment, Cox and Kings.
So in all your responses, one concern that you have been expressing is how does the law take into account the realities in our country? How do we make policy that takes account of the reality of the country? And this is yet another example of, where companies come together, but formally one company would sign the contract, but you in fact have other related companies or independent contractors or subcontractors actually engaged in the project. And you make the point that if you want to have a comprehensive resolution of this dispute, then these are persons, we must enable their participation in the resolution of the dispute. So we don't have multiple proceedings, we don't have multiple, outcomes of the same dispute where the contract or the project is implemented by all of these parties, and they each have a perspective, a role, and an involvement in how things have actually happened. Thank you so much. So I had a few more questions, one on mediation, but probably I think we should give some time to, because there are questions from the participants. The first question is from Kalpana Borse, who is from Prudent Law Service. She asks, where does India stand in terms of global recognition as an arbitration institute?
One word is that we have to travel a long distance, but we can't be totally pessimist about it. That, sometimes we think that one person would be able to change it, or one institution will be able to change it. It can't be changed. Every stakeholder, from the stage of a litigant, the law firms, the judges, the court, everybody has to work together to promote India as the arbitration hub. If I say that Chitra will be able to change it, no. Hemant will be able to do it, no. Everybody has to join hands together with a common goal of making India as the preferred mode of arbitration.
Thank you, sir. So all of us sitting in this webinar have a responsibility. Thank you for
That's right. That's right.
The next question is from P. Raghavendra, who's from John Deere Financial India Private Limited. Raghavendra asks, what is the fate of arbitration awards? Since it goes to the stage of execution petition being taken up by courts. So I think the point he is making is about delays that come in at that stage in the execution of arbitral awards.
No, the concern is actually very genuine, because long back in India, it is always said the problems of the decree holder starts after he gets a decree, at the stage of execution. And CPC Order 21 is applied at every stage. My suggestion in all these webinars or the conferences is that we should have, like Debt Recovery Tribunal has applied second schedule of the Income Tax Act for a summary recovery proceedings. But the question is that can't be done in respect of ad hoc institution, ad hoc arbitration. It can be done by the institutional arbitration, subject to the qualification of the recovery officer or the experience which is required. And then possibly if we give power to the institution like tax recovery officer, things can change where there will be summary execution of the award rather than before the civil court, where all kind of objections are raised and had to be decided. Once the matter goes to the civil court, there are multiple forums also gets into it. Like before the civil court, the matter will go before the executive court, that is the sub-judge first class, then the district judge, then the high court, then the Supreme Court. There are 4 different forums. So we have to cut down on that forums also. Each forum will take substantial number of years for this season. So second schedule of the Income Tax Act is one solution, but somebody expert on in this subject can possibly suggest something better also.
Thank you, sir, for that. There is this is a question from Naseem Kachi, who is from My Gov Change Maker and Campus Ambassador. The question is, what are the major important points or ideas that we should discuss with the clients so that disputes come to a resolution within a given time frame in arbitration? I thought this was a very interesting question and something that all of us can benefit from your response to this when we speak with clients and parties.
The best solution is your subject to mediation. Mediation should be conducted. That is, mediation takes away the litigation from the court system. The arbitration is not. Arbitration, the matter still remains in court in case of, firstly, objections against the award, then execution. But mediation takes care of all situations in one go. So, I don't know what the lawyer advises client about no. I find it difficult to answer.
Sure. I think if I might say something, sir, in response.
Yes.
Naseem, I would, would like for you to, or for anyone who is advising clients to talk about what the benefits, the autonomy that arbitration gives, both in terms of being able to structure the process, choose your own judge, which could be, for instance, an engineer if it is a construction dispute, because a person would know better, how issues come up, as well as to set time limits, to be able to go to an institution, an arbitral institution that can guide you on how, can take care of a lot of responsibilities that go with, conducting an arbitration. So these are aspects that you could speak to your client about. And also point to the fact that these are time limits that are meant to be implemented, that are meant to be honored. I am very apologetic to the...
Chitra, just because of your viewpoint, they should advise to not have ad hoc arbitration, they should have institutional arbitration. Institution looks like that will be, because you know about the fee, you know about the time schedule, the qualified arbitrators are also there. That is much better rather than ad hoc arbitration. That will be one suggestion which I would offer.
Yes, sir. Thank you, sir, for that. So my apologies to the participants. There are many questions, but because we didn't have time, I have just picked a few. We are very encouraged by these questions and your interest in the webinar. I think at this point, what I will do, sir, is thank you for what you have shared with us from your experience in this session. We move to the second session, which is a discussion between Aishwarya Mahesh, who is the Deputy General Counsel at Dwara Holding and is also involved with the Nani Palkiwala Arbitration Center in Chennai. She will be in a conversation with Mr. A.J. Jawad, who is the Registrar of the IAMC Hyderabad. And I would like to hand over the moderation to Aishwarya. Thank you very much, Justice Gupta, for sharing your thoughts.
You are welcome, Chitra. Thank you very much.